Good day, HR students. This is Dr. Raizamisi Narciso, your subject teacher for the subject Bahr 312 Special Topics in Human Resource Management. The previous topic tackles about the origin, evolution, and basics of human resource management. And I hope that you were able to internalize how important our course is to the success of a certain organization. So, right now, I will be discussing to you Big Picture A, Unit Learning Outcome B, as it aims to explain the constitutional and legal framework of human resource management. Okay, so but of course, we have to know the terminologies that we will be discussing in this unit. So starting with labor relations, which is defined as the aspect of quality that holds together the social partners, labor and capital in the attainment of their mutual goal, just and equitable pay and treatment and fair return of investment. Next is employer, who includes any person acting in the interest of the employer directly or indirectly. Then we also have employee. These are persons in the employ of an employer. Another is the regular, where the employee has been engaged and perform activities which are usually necessary in usual business. Moving on to project, where the employment has been fixed for a specific project or termination of which has been determined at the time of the engagement. And now the casual, someone who is not a regular employee or whose service is broken or employed less than 6 months in the company. Then probationary, which is less than 6 months of employment from the date of the employee started working, whose services may be terminated for a just cause or when he fails to qualify as regular employee. So lastly is the fixed contract employee, when there's a day agreed upon by the parties for the commencement and termination of their employment relationship, and sometimes it's also a project employment, no. Okay, so the legal aspects of HR have changed dramatically in the past 70 years, and the emphasis on the right of workers to perform unions and establishing basic parameters such as length of a working week and establishing a minimum wage has changed. The emphasis of most recent legislation has been grounded in social responsibility, and government has compelled employers to become more socially responsible. And at some point, our government is can also be a pressure group or entity that pressures the private na mga establishments to give its best also to its employees. And in the process, the costs of government mandated changes have been shifted to consumers. Okay, some of the most important key points that HR practitioner must consider is that managing human resources is oftentimes fraught with legal implications. Okay, so that is why in your curriculum we have two law subjects which actually tackles about social legislation or labor laws, and then yung isa is about sa negotiations. Kasi it's very crucial that we have a bit of know-how about this type of this subject. It's because it has an implication in managing the human resources in the future work field. And ignoring the legal aspects of human resources can result in legal lawsuits. Okay, so just like what we are commonly hearing about ignorance of the law excuses no one. So same in the employer side. For example, in the Antisexual Harassment Act, if you tend to ignore some complaints about that, so there might be chances nga ang employer mismo is kanang makasuhan or maigo about ana because you did not take any actions out of it. So that's why it must not be taken for granted yung mga legal aspects. And it is the responsibility of the management to become educated in labor laws. So the constitutional and statutory provisions protecting labor are derived from the police power of the state and based on the social justice. So before it was formulated, of course, it actually undergoes series of consultations and mga public forum before it is um, mandated in the law. Human resources personnel must be familiar with the requirements of the legislation discussed in this lesson. No? This task has made the jobs and activities of HR employees more complex and challenging. That is why I'm always emphasizing no na kita ng mga HR, we are not just an kanang employee in an organization who manages the um, record keeping aspect inside the company, but we are somewhat also a little lawyer that must have a know-how about how to foresee the legal aspects in the human resource management. And most experts expect that this trend will continue, although the pace of implementing changes is likely slow. Okay, so take note, guys, that today's generation of workers are now well informed about labor rights. Kaya nga, di siya same before na madali lang tanggalin ang mga employee at the whim of the owner. Everything has a process. So this is also one of your challenges as an HR practitioner in the future. So dapat familiar kayo sa mga labor laws existing in the Philippines, and to make it more complicated, as employment becomes borderless nowadays, there's also a need to familiarize other countries' law as well, especially if nag-branch out um, ang iyong company into an international setting. So, kaya nga, merong mga HR na din na nagproproceed ng law kasi meron na silang prior knowledge on law in the academe, no? So, maybe sa inyo na mga batch right now, baka mag-decide kayo na mag-proceed ng law after getting this course, no? So, in the future. So here are some notable declaration of principles and state policies the Constitution provides in relation to labor law. So we have Article 2, Section 18, which highlighted that the state affirms labor as a primary socio-economic force. It shall protect the right of workers and promote their welfare. So also pursuant to this declaration of principle, Article 8, Section 3 expand its labor policy by providing that in addition, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities to all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including right to strike in accordance with the law. So they shall be entitled to security of tenure, humane conditions of work, and living wage. They shall also participate in policy and decision-making processes affecting their right and benefits as may be provided by law. So the state shall promote the principles of shared responsibility between workers and employers and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. So the state shall regulate the relations between workers and employees kasi yun ang mga merong common na mga misunderstandings, no, or disputes, yung employee and employer. Recognizing the right of labor to its just share in the fruits of production, and the right enterprises to reasonable returns to investments and to expansion and growth. So, yun yung constitutional basis for the human resource management, no? So, having this declared labor law, it gives emphasis on the rights and protection of the employee. So, the more na tayong mga HR must be very careful on dealing with labor negotiations and concern, as they are well protected by the law. Kaya nga, it's always a misconception to say nga, dali ra kaayo ang mag-HR. No, it's not. It's complicated. And kailangan talaga mataas ang pasensya, understanding, and knowledge on dealing with human resources. Okay, so next topic is the statutory and international basis of right to self-organization. Yung mga mag-form ng mga organizations or unions or clubs inside the organization. So, as we all know, there's a lot of issue arising to this matter on self-organization. Maraming mga employer who prevent employees from forming a union or organization in their company. Marami talaga during sa interview phase pa lang, ginabar down na nila daan ang mga applicants who've been a member or an officer of a certain union before, no? Kasi by doing so, they are perceived to hold a lot of power that they might use against the employer. So, kaya it is understandable na meron talagang organization who have prejudice for self-organization matter. So, however, the Labor Code reinforces this constitutional right to self-organization under Article 211. Okay, so also two Geneva Conventions ratified by our Senate and thus become part of the law of the land guarantee workers the right to self-organization. So it's under International Labor Organization Convention 87, in which the freedom of association was formulated. Then it's in the ILO Convention 98 where the right to collective bargaining also started. So they do not second guess themselves, but rather move forward on projects with clear vision. So they feel a sense of certainty and believe that they are doing the right thing. Okay, so if an HR has a doubt or question relating to employee rights or relation, the labor code can answer it right away. So the labor code originally, the labor code of the Philippines was enacted during martial law by the virtue of Presidential Decree 442 by President Ferdinand Marcos. No, that's one of the best legacy nga gipabilin jud ni President Ferdinand Marcos. So it is divided into 6 major parts. The Book 1, talking about pre-employment. Ang Book 2 naman is the HR Development Program. Ang Book 3 is about conditions of employment. Book 4 is health, safety, and social welfare benefits. And Book 5, labor relations. And lastly, Book 6, the post-employment. So it prescribes the rules for hiring and termination of private employees. The conditions of work including maximum of work hours and overtime, employee benefits such as holiday pay, yung 13th month pay and retirement pay, and the guidelines in the organization and membership and labor unions as well as in collective bargaining. I know that some of this was already discussed in your compensation administration subject, most especially yung mga pays na kailangan natin siya especially i-compute other than the basic pay. So this is one of the best legacy that the late president imparted to Filipino constituents. Kasi noon, mostly taken for granted talaga yung mga employees, no? That is why it is just easy for the manager or supervisor to apply military HR. Okay, kasi wala kaayoy right ang ato ang mga employees that time. But since this is formulated, so that is also why the leadership style of our managers or supervisors or the administration also changes. Okay, so good for the employee na part. But of course, it's not just the employee who can benefit about this, but also yung mga employer din, meron din naman silang tinatawag na management prerogative, in which we will discuss it later. So, there are 3 different kinds of employee position in the Philippines, and they are determined by the nature and or existence of activities that an employee is required to perform. So, the employer establishes the terms and conditions of the employment contract, which should be structured according to the legal provisions set by the Philippine labor laws and regulations. The higher the classification of the employee, the greater its responsibilities is. So, in larger organizations, management is often broken down into 3 levels. Okay, so the upper management, middle management, and then the first line management. So upper management includes the top executives who are highest on the management hierarchy. Middle management includes communication link between upper and lower management. And lower management includes first line managers and supervisors who are in the bottom of the management hierarchy. So now, what is the role of a managerial employee? So the term manager generally refers to anyone who is responsible for subordinates and other organizational resources, and even meron ding levels of managers sometimes for big organization, yung top, middle, and first line managers, no. Managerial employees may therefore be said to fall into these 2 distinct categories. The managers per se, who compose the former group which is the top one described above, and the supervisors who form the latter group. So, whether they belong to the first or the second category, managers vis-a-vis employers are likewise employees. So, talking about the supervisory employee, let us first differentiate managerial and supervisory employees. Supervisor has a more internal focused responsibility for implementing the manager's decision through the work of subordinate employees. Managers have a significant external focus to the world outside the unit. Thus, in terms of hands-on management ng mga employees, it's the responsibility of the supervisor to ensure that everyone does their job well. So once a decision is made on what to do, supervisors have a significant role in deciding how to do it, how to achieve the objective established by the manager. Kumbaga sila yung nag-i-implement about the memo and instruction ng top management and even the policy. Supervisors often perform the same kind of work that the subordinates do, pero with higher responsibilities compared to their subordinates. So they will be blamed for any mishaps and praised for a successful job. And on the other hand naman, managers do not do the daily work of a unit as a regular part of their work. They may do it more on exception basis or in resolving more difficult problems facing the unit. So, mas mabigat ang trabaho ni manager kasi they look more into the big picture. Strategic yung mga decisions ni manager and it can make or break the company. But he or she closely coordinate with the supervisor as well and also with the top management. So, yung rank and file employees, yun yung mga nasa lower management, okay? They do the daily task and then they are being mandated or supervised by the middle or the supervisors or even the manager or even the top management. But they have really their head. So, kung sino yung head, so dun sila nag-report directly yung ating mga rank and file employee. Usually, they does clerical work na. So the next topic is about the types of employee in terms of tenure under Article 280 of the Labor Code. And I know that every one of you are already familiar with these types of employee. So let us review this topic na lang, starting with the regular employee. So pursuant to Article 280 of the Labor Code of the Philippines, the primary standard that determines regular employment is the reasonable connection between the particular activity performed by the employee and the usual business or trade of the employer. The emphasis is on the necessity of desirability of the employee's activity. Thus, when the employee performs activities considered necessary and desirable to the overall business scheme of the employer, the law regards the employee as regular. So, ito yung pinaka-aim ng marami to become a regular employee in a certain company. Kasi marami itong perks as compared to those who are not. So, you'll have a security of tenure by being regular. You cannot be easily terminated without due process and ikaw yung prioritize if merong mga benefits, allowances, and incentives na matatanggap. So, pahirapan maging regular for several company and you really have to bring your best foot forward to impress your boss. The 6 months probationary period is very crucial and there's no room for mistakes. All eyes are on you kasi this is the basis of your boss to continue working with you. Okay, next one is ang project. Project employment contemplates an arrangement whereby the employment has been fixed for a specific period or specific project or undertaking whose completion or termination has been determined at the time of the engagement of the employee under Article 280 Labor Code of the Philippines. So since the employee services are coterminous with the project, the services of the project employees are legally and automatically terminated upon the end of completion of the project. So this is a fixed start and end as stipulated in the contract. So remember that projects are non-routinary That is why meron siyang timeline. Example is the flyover project constructed in Tagum. There are several key personnel who are specially hired para mag-monitor and magtutok ng proyekto. So after matapos ang project, estimated this year, for example lang, then those key personnel contract will also be terminated. Okay, so then we also have casual employment. This is actually very common in government sector. A person is a casual employee if they accept an offer for a job from an employer knowing that there is no firm advance commitment to ongoing work with an agreed pattern of work. For example, if an employee is employed as casual, their roster changes each week to suit their employer's need, and they can refuse or swap shifts that could mean they are casual. So specifically under the Fair Work Act, a person is a casual employee if they are offered a job. The offer does not include a firm advancement commitment that the work will continue indefinitely with an agreed pattern of work, and they accept the offer knowing that there is no firm or commitment, advanced commitment, and become an employee. So maraming ganito sa government, and even umabot na ng more than 20 years in service. Ang iba naman since start of employment until nag-retire sila, casual pa rin. So, but in the private sector, the labor code also consider regular employment as a casual arrangement. When the casual employee's engagement has lasted for at least 1 year, regardless of the engagement's continuity, the controlling test in this arrangement is the length of time during which the employees engage. So, iba kasi sa government kasi it is governed by the Civil Service Code. While sa private sector naman, it shall follow the DOLE, which is, or the Department of Labor and Employment, which is much stricter when it comes to implementation of the tenure of the employee. So, dili siya pwede nga i-leave na to siya in ana kataas hanging ang isa ka empleyado in a private sector. So then we have probationary employment, which refers to an arrangement where the probationary employee is hired on a trial basis to afford the employer an opportunity to observe the fitness of a probationary employee while at work and to ascertain whether he will become a proper and efficient employee. So for private employee, this stage is very crucial. Dapat you really have to set your best foot forward. So dito na part mag-a-assess ang mga supervisor if you will be regularized or not. After 6 months, they will have to decide if dili ka nila irregular. Then you will be terminated afterwards. Pero at some point, napod be mga conditional pod nga cases. They will be given an extra 2 months, for example, para ma-prove yung performance nila, most especially katong na mga mistakes during sa probationary period. So, giving them second chances, but then, meron pa ring limitation kung hanggang, how long that extension will be given. So, next naman is the matter on occupational safety and health in companies in the Philippines has been mandatorily monitored by the Department of Labor and Employment, and even it is required to conduct an 8-hour mandatory training for all. So even in UM, we have done that. Classes were suspended to give way in this mandatory training for employees. So what is this all about? This law is enacted to reduce risk or accidents or injuries by identifying and mitigating hazards, improved efficiency and productivity due to fewer employees missing work from illness or injury, improved employee relations and morale. A safer work environment is a less stressful work environment. So actually, maraming coverage ang discussion ani nga topic, and nakakategorize din siya kung gaano kalaki ang organization. Napod siya mga specific requirements. But the common thing to have are the following. To keep in the employer establishment, such as first aid medicines and equipment, as the nature and conditions of work may require in accordance with such regulations at the Department of Labor shall provide. To have services at a full-time registered nurse when number of employees exceeds 50 but not more than 200. So kailangan ng mga registered nurse. When the number of employees exceeds 200 but not more than 300, the employer shall get the services of a full-time registered nurse, a part-time physician and dentist, and an emergency clinic. Okay, so when the number of employees exceeds 300, the employer shall obtain the services of a full-time physician and dentist, and a full-time registered nurse, as well as a dental and clinic and an infirmary or emergency hospital with one bed capacity for every 100 employees. So the physician, nurses, and dentists employed shall have the necessary training in industrial medicine and occupational safety and health, and it shall be the duty of the employer to provide all these necessary assistance to ensure the adequate and immediate medical and dental attendance and treatment to an injured or sick employee in case of emergency. Okay, the state shall promote and develop a tax-exempt employee compensation program whereby employees and their dependents in the event of work-connected disability or death may promptly secure adequate income benefit and medical or related benefits. So the state insurance fund is created out of monthly contribution by the employer for the employee. And this insurance fund includes social security system for private and government service insurance system for public. So these are mandatory benefits that shall be given to employees, and for private, SSS provides it, while for GSIS naman, it's the government. So marami ang naiinis about having deduction to such mandatory benefits. Itong mga benefits is ma-appreciate ng mga employees in times of emergency, such as encountering accidents, health problems, maternity benefit, loans, and in retirement. So that is why it's important to know about these mandatory benefits. And not just that, we also have PhilHealth and HMDF or Pag-ibig, yung other na mga mandatory benefits that must be provided. Okay? So moving on to the topic of labor relations, it is the interaction between a company's upper management and the rest of its employees. So why do we need this? The purpose of great labor relations para mas tumatag ang employee and employer relationship, and magagawa lang ito by measuring employee satisfaction, identifying and resolving workplace issues, and providing input and support to the performance management system of the company. So ito yung mga common labor dispute ng misunderstanding ng both parties which may result in an undesirable conflict. So kaya several companies took labor relations seriously to avoid legal cases and establish connection and harmony as they coexist in the company. So here are the sources of conflicts. First is the manner by which hierarchical demands are made or executed, clash between management prerogatives and labor rights. So I already told you na in protection naman din sa employer na side, meron din naman silang management prerogatives. Pero, yung sa mga management prerogatives na identified, meron din naman tayong tinatawag na labor rights that the employees can also question about those management prerogatives nga gi-exercise. So, just share in the fruits of production and fair return in investment, expansions, and growth. Okay, so let's have a comparison of management prerogatives and labor rights. Now, yung admin, they have the power to manage employees. Pero yung mga employee naman, they have the right to participate in decision making. Okay, most especially if such decision nga gi-create sa ato ang management is murag dili siya nindot. So yung mga employee can also participate in it. Most especially if kailangan talaga ang intervention nila. So, yung management naman have the power to hire. Pero yung sa labor rights, again, meron tayong mga union security rights which may include closed shop. So, as mentioned before, there are really employer who really blocked those applicants nga member na daan og isa ka union. It's because they are afraid nga if kana siya nga organization is wala pa union, they might be the one to start it. Okay, so dili na siya pwede kasi ang mga employee really has the right to self-organization. Then the management naman has the power to fire. Actually, pwede jud magtanggal. Pero in the side naman sa labor rights, meron ding security of tenure na tinatawag. Most especially if regular na ka, it would not be very easy for you to get terminated unless lang natin ginatawag nga just cause. Nga nganong kailangan or tama raman jud nga ma-terminate ka. Okay? So, dili po na siya dapat nga ma-exercise ng tungod kay trip lang ni employer nga mag-terminate. Tungod kay dili lang ko ganahan personally. So, dili na siya pwede nga ma-apply. Okay? It's because yung labor, yung mga employee also has its right. So, they also have the power to transfer employees from this nga location to that different location. Pero same pa rin ang position. However, in the labor rights, they have the right to refuse it as it is obviously to thwart unionization or on any other ULP act. Okay? And they have the power to promote or demote. Pero yung labor rights, they have the right to question nganong gi-promote or nganong gi-demote. Okay? Kaya para ma-check if it's unfair or discriminatory in nature regarding sa reason. Okay? So, power to lay off or lock out. They have the right to question nganong mag-lay off man. Okay? So, that is why napod sila ang labor pod napod sila right to conduct strike. Okay? So, next is power to lay down policies. And also, our employee, they have the right to participate in decision making to collectively bargain. And then, power to discipline, pwede ta mo disiplina for as long as nag-agi po jud og tama nga due process. Nya, power to set working hours, pero sa labor naman nato, napod sila right to file grievances. Okay, it's still something about negotiation pa rin. Because there are really employees who cannot really work at night, for example. They cannot also work overtime because of this, because of that. Okay, so fair return in investments and expansion. And of course, our employees also have the right to just share in fruits of production, such as giving the incentives or commissions nga para jud sa ilaha. Okay, so see, it's not only pro-employees ang naa sa labor code, but also the management also has its what we call management prerogatives. Okay, so dili man siya ingon nga one-sided ang labor code. Okay, so next is we shall discuss the unfair labor practices under Article 247, 248, and 249 of the Labor Code. So, it violates constitutional right of work to self-organization, and it is the right of workers and employees to form, join, or resist unions, organizations, or associations for a purposes of collective bargaining and negotiation and for mutual aid and protection. So it also refers to the right to engage in peaceful, concerted activities or to participate in policy and decision-making processes affecting their rights and benefits. Okay, so pag once merong violation dito to self-organization, of course, maigo jud ang employer ani because our employer really have that right to self-organization. Okay, it disrupts industrial peace also. Then hinders promotion of healthy labor management and violates civil rights of the parties. So those are the unfair labor practices that could be ibises for a just cause kung nganong mo complain ta sa side sa employer, towards the employer. So let us now discuss about the right to strike or the strikes and work stoppage or lockouts. The right to strike is guaranteed by the Constitution and the law. Okay, actually allowed jud nga mag-strike and then mag-temporary stoppage sa trabaho. Employees can only strike on two grounds. deadlock in collective bargaining negotiations, and unfair labor practices. Meron tayong mga labor disputes nga na-experience. They are only allowed with the two conditions. So if that does not belong to the two conditions, then they are not allowed to go to strike. So further conditions before a strike can be staged, kailangan ma-provide ang kaninga mga requirements, no? So, hindi pwede yung feel lang naming mag-strike, okay na dapat so dapat mag-follow jud ang mga employees nato sa process. So, first, a strike notice must be filed with the Department of Labor, okay, 30 deadlock and 15 days in case of unfair labor practices. So, strike must be approved through secret balloting by the majority of the members in the bargaining unit so that they can have a consensus nga nganong kailangan man siya nato mag-strike, no? So, the strike can be declared illegal if there are shortness of any of these conditions. Ang ending, baka ang employee pa ang mapasama. So, dapat na i-meet talaga ang requirements and condition first. Okay, so the security of tenure of employees is guaranteed by the Constitution and by law, and moreover, an employee unjustly dismissed from work shall be entitled to reinstatement without loss of seniority, rights, and other privileges, and his full back wages, inclusive of allowances or other benefits or their monetary equivalent computed from the time his compensation was withheld up to the time of reinstatement. So, that's the law on termination. That is why when we terminate somebody, it is needed to have all the evidences of or the reason for termination. So, babalik na naman tayo sa evidence-based management at this topic. So, terminating employee is very complicated than an employee resigning in the post. Kasi, dapat mong patunayan na meron talagang just cause for termination as employees are protected by law. No? So, what are the following nga pwede na ito makonsider in terminating? Serious misconduct or willful disobedience by the employees of the lawful orders of his employer or representative in connection with his work. Okay, so yun. Insubordination can also be a reason. Gross and habitual neglect of the employee of his duties na ay gipatrabaho, wala gitrabaho, always late, sige absent, for example. Fraud or willful breach by the employee of the trust reposed on him by his employer or duly authorized representative. So, na siya mga monkey business, for example, nangatik siya, ana. Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representative, and other causes analogous to the foregoing. So, however, there are also authorized causes under Article 282. First is the installation of labor-saving devices or redundancy. Okay, so for example, nag-invest si employer ng machines, equipments, robotics. So that could be a authorized causes nga para i-terminate nato ang atong mga empleyado kasi para asa man ang daghan kaayo nga labor nga kumakaya naman siya sa machine. Okay, so retrenchment to prevent losses or closing or cessation of operation. So there are a lot of companies right now nga lead to retrenchment. It's because of the crisis brought by pandemic. Okay, that could be an example for that. So there are also other authorized causes when an employee has a disease wherein his continued employment is prohibited by law or prejudicial to his health or to the health of his co-employees. Labi na tong mga makatakod nga disease. So retirement also. So yun. The Bill of Rights of the Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. So what is due process? It means that an erring employee is entitled to a day in the court with the assistance of counsel if he so desires, so to confront the witnesses against him. So the twin notice requirement of termination due to just causes means that the employer should give the worker two written notices. Dili pwede nga idiretso jud siya terminate. So kailangan maghatag ta og duha ka written notices before terminating his employment para matagaan og chance ang ato ang mga employees to counteract or to answer the accusations ang gihatag sa ilaha. Okay, so here are the summary of the salient points of labor code. Primacy of free collective bargaining and negotiations, free trade unionism, free and voluntary organization of strong and united labor movement, adequate machinery for expeditious settlement of disputes, workers' participation in decision and policy-making processes, dynamic and just industrial peace, encourage free trade unionism and free collective bargaining, right to engage in concerted activities, security of tenure, and all doubts in implementing and interpretation of the labor code provisions, including the implementing rules, shall be resolved in favor of the labor or the employee. So actually, medyo baga jud ang labor code, guys, but then you can really access it in the internet and you can even download the labor code if you really want a detailed nga iyahang provisions. So now let's proceed to the Wage Rationalization Act or the RA 6727. Okay, this is a law passed in 1989 to rationalize the wage fixing of minimum wages and to promote productivity and gain sharing measures. So after EDSA, wage fixing has been delegated to the Regional Tripartite Wages and Productivity Boards, otherwise known as the RTWPB. So, sila yung nakatoka na mag-identify if pila juday ang minimum wage per region. Nganong per region man, nganong dili man siya general. It's because lahi-lahi man gug cost of living ang matag region. For example, diri sa ato sa Region 11, kung mopalit kag maruya, barato ra na, tag 5 ra na. Pero if mopalit kag maruya dito sa NCR, wala, tag 20 na na siya. So, ina nakamahal ang mga palitunon dito. Mga gulay, for example. So, here in us, pwede ra ta magtanom sa backyard nato. Then, pwede ra po ta makapalit og mga barato ra kaayo. That's why, in terms sa minimum wage, mas lesser siya. Kasi yung mga renta ng mga rent sa house din diri sa Region 11 is cheaper po din as compared to NCR. Okay, so ang mag-identify ng cost of living is ang RTWPB. So the Regional Tripartite Wages and Productivity Boards. It's not the Department of Labor. So to regionalize wage fixing to reflect the prevailing cost of living in a particular region. So as shown also, a National Wages and Productivity Commission was created whose function is to exercise technical and administrative supervision over RTWPB. So, gina-check and balance gihapon po nila ang RTWPB regarding sa ilahang mga proposal. So, that's the role of the National Wages and Productivity Commission. So, we know that a lot of establishments are not even following the minimum wage rates right now, diba? Actually, companies can request for reconsideration about not following it, pero it has a lot of supporting documents nga kailangan nimo i-submit sa Department of Labor. Ngano wala man ka nag-follow ana. Okay, so as of now, we have wage order number 20 nga natay mga changes ani. Actually, for non-agriculture, our effectivity date for the new minimum wage is yun, 396. Yun yung minimum wage nato sa Region 11 for non-agricultural. For agricultural sector naman, we have 391. And for retail or service employing not more than 10 workers, we have 381. Okay, so enacted in February 14, 1995 is the Antisexual Harassment Law or the RA 7877. Tunong jud siya Valentine's Day gi-enact, guys. So under this law, companies could not just ignore the complaints no? Kay kung ignore na nimo, kung kang kinsa ni sila misumbong, ikaw na noon ang makasuhan kay wala kaning wala kaning take action sa katong gisumbong sa imuha. So employers and heads of office are required to promulgate appropriate rules and regulation to avoid this sexual harassment. What is sexual harassment? This is defined as any work, education, or training related sexual harassment committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who having authority, influence, or moral ascendancy over another is the work of training or education environment demands, requests, or otherwise requires any social favor from other, regardless of whether the demand, request, requirements for submission is accepted by the object of the said act. Okay, so even in the educational setting, for example, yung professors nyo, nagbigay ng kondisyon para makomply ang 7.2, pumunta ka dito sa boarding house. So that could be an example sexual harassment that you can file about it. Pero what if baliktad? Si student naman, si student ang nangharas sa kanyang professor. Okay, so that is not covered by the Antisexual Harassment Act. You can file another law about that kind, about that type of harassment, pero it's not in the antisexual. Take note that in the antisexual harassment, dapat si harasser is mas mataas ang ranggo and really has an influence over that specific nga katong naharas. Kung sa sa employment nga setting, if giharas ka sa imuhang boss, you are the secretary, giharas ka, gigunit-gunitan ka for example, or even nag name calling sa imuha, so ikaw nga secretary, you can really file for that. Pero, for example, you were harassed by your co-employee with same level, so that could not cover under anti-sexual harassment. So, remember that there should be a moral ascendancy over the others. So, sige lang, on second semester, this topic will be discussed thoroughly as this is one of the topic that needs to be delivered before deployment of your OJT. So, madiscuss ni siya and it will be discussed by a lawyer. Okay, so lastly is the new labor relations law or the RA 9841. This is the most controversial law and social legislation which is passed in 2008, otherwise known as an act strengthening the workers' constitutional right to self-organization, amending the Labor Code of the Philippines. So, loudly protested not only by businessmen but by foreign chambers as well. No? Kay, tungod kay daghan lagi complaints about not allowing them to self-organize. So, mo nang giratify siya ang kaning under ato nga labor code nga specific nga provision para mas strengthen pa jud ang right to self-organization sa mga employees. Okay, so here are some of its salient provision. Filing of petition for certification election by a federation or national union issuing a charter certificate to an unregistered local participating in the certification election. Commingling of rank and file and supervisory unions operating within the same establishment in the same federation and national unions without qualifications or conditions. Employer as bystander in certification election, unlike before when the employer is a legitimate party in the proceedings. And then, kumbaga pantay na lang, no? Then, non-disclosure of who are the officers and members of the union. So, ginakip jud siya ang secrecy, ana, so that the employer cannot influence those who are members of that union. Okay, so these are the topic covered for Big Picture A, Ulo B, and I hope that you'll be able to comprehend the topic so that you can participate in the next video conference. So have a good day.